As I read through Justice Thomas's concurring opinion in Dobbs, I think of the heads up he gave us about the far-right majority's plan to overturn other well-established constitutional rights that Americans had just taken for granted in their daily lives. In particular, Justice Thomas calls on the court to, quote, reconsider all of this court's substantive due process precedents, including the court's 1965 decision in Griswold, as well as the court's decisions in Lawrence v. Texas and Obergefell. These are, of course, the three cases establishing the constitutional rights to contraception, non-procreative intimacy, and marriage equality. In casting doubt on these decisions, Justice Thomas let us know that the far-right majority on the court is not satisfied to have deprived millions of Americans of the right to an abortion. Rather, the majority is on a rampage against other freedoms currently enjoyed by the American people. As someone who has repeatedly drawn attention to the partisanship of the far-right majority on the court and the fact that these 6 justices are not people who can simply be reasoned with using sound legal arguments or even the court's own precedents, I can't help but think of Justice Thomas's glaring omission of another case, and this has been discussed to some extent today. And that case is a 1967 decision called Loving v. Virginia, which established the constitutional right to interracial marriage. It seems to me that following Justice Thomas's logic about reconsidering the court's substantive due process precedents, the Loving decision would fall naturally on his list. In fact, the Supreme Court's 1973 decision in Roe v. Wade explicitly relied on the decision in Loving v. Virginia. Moreover, the case is cited multiple times in both Justice Alito's majority opinion and in the dissent in Dobbs. Now, my Republican colleagues would say that Justice Thomas's omission of Loving v. Virginia is nothing at all to do with the fact that he's a black man married to a white woman. Never mind that he tried to block the January 6th committee from seeing documents that may have included evidence of his wife plotting the insurrection at the Capitol. He would never do something that is in his personal interest above that of what the law requires or sound legal reasoning requires.